uploaded on the tab for additional notices and orders. I followed that tab. I filed my reply also. But the order was uploaded in the normal notices and orders. No hearing was provided to me. Millards, I got to know of the order, Millards, when my bank was issued a notice under Section 79. Millards, subsequently, Millards, it was in December, they issued a notice, the government to the bank.
Notice to show cause you replied.
I replied notice to show cause also, Millards. Subsequent to that, no hearing given. They passed an order in a different tab in 2024, Millards. Thereafter, in December 2025, the government issued a notice to the bank, and then the bank informed me. 7 days later, Millards, I filed this writ petition.
लिखे निंदी दी the writ petition. Yes, Mr. Dhanuka.
My lords, I'll just briefly narrate the facts and then I'll just present my case. My lords, I'm a small-time dealer engaged in supply of
Against what? Against appellate order?
against an adjudication order, my lords.
Why not appeal?
My lords, why not appeal? My lords, I'll impress upon two things. First of all, my lords, it was issued under the additional tabs. Everything, show cause notice, order, everything. Number one. Number two, my lords, no opportunity of personal hearing. And number three, my lords, most vital fact is, my lords, on the self-same issue, my lords, I was summoned under Section 70 of the CGST Act. I appeared, and thereafter the concerned authority, after having been satisfied with my response, had clearly held that no tax is payable. Subsequently, on the self-same issue, my lords, a notice is issued under Section 74, tax is confirmed, and recovery has been made, my lords. Now, my lords, my humble submission is, my lords, because this entire issue on the self-same issue, my lords, the adjudicating authority was satisfied with my response and had dropped the proceedings. The present proceedings are barred by the principle of res judicata, my lords.
Very good.
And my lords, I am actually a very, very small time dealer, my lords. My entire supply is regulated. I am engaged in the supply of superior kerosene oil, my lords. I am authorized as an agent on behalf of the state, my lords, Department of Food and Supplies, my lords, wherein I am being granted a license to act as an agent on behalf of the state. My lords, my purchases are regulated, my sales are regulated, my prices are regulated. Now, what had happened, my lords? In December 2017, I had supplied 12 kiloliters of superior kerosene oil to a dealer called Swapan Kumar Sarkar. Now, against this 12 kiloliters, the taxable value was coming to around 2 lakh something rupees, 2 lakh 45,000. But what happened while filing my GSTR1 returns, my lords? Instead of 2 lakh 45,000, the concerned person had disclosed or reflected 2 crore 45 lakhs. It is merely this error, my lords. It is just that the decimal places got shifted. So it was a typing error or typocast error, my lords. Thereafter, my lords, because this error was there in GSTR 1 and because my taxes was paid on my actual sales, there was a mismatch in GSTR 1 versus GSTR 3B. So accordingly, I was summoned and I had duly adduced bank statements. I had duly adduced my ledger, party ledger, and basis that the authority, the concerned authority, vide an order dated 4th. Sorry, my lords, I'll just indicate the order date, which is 13th of April 2022, had dropped the proceedings. Now, my lords, subsequently, what has happened is on the self-same issue, my lords, the entire proceedings has been initiated and order has been confirmed. Now, my lords, on the additional piece and the fact that the show cause notice and the order has been issued under the additional tab, my lords has already taken a view that the matter can be remanded back. And also because there's no opportunity of personal hearing which has been granted. Why I place my case on a higher footing is, my lords, because this issue already stands concluded and therefore the authorities are barred from again raking up that issue on the same aspect, my lords. May I kindly just take my lords through the first summons, my lords, which is at page 39, my lords.
39.
39.
Yes.
So, my lords, may kindly see just the table, my lords. I'll not trouble my lords with anything more. So, my lords, because there was a mismatch or there was a typing error, my lords, which led to a tax liability of more in GSTR 1 and GSTR 3B, therefore there was a tax liability which was disclosed, my lords. Thereafter, my lords, I had appeared and had tendered a lot of documents, my lords. May just kindly, I'll take, my lords, only two things, my lords. Kindly takes the invoice for the supply, which is at page 37.
37.
Page 37. This is with respect to only one supply, my lords.
Yes.
My lords, kindly see the taxable value column. It is 2,53,463, my lords.
Yes.
And my lords, kindly thereafter see page 38, my GSTR 1 returns. And it would be quite obvious that it was just a error in filling of the returns, my lords. Kindly see the invoice value. It is matching with page 37, 2,66,159.
Page
38, my lords.
Page 38.
Yes, this is my GSTR 1.
Yes.
2,66,000 in total invoice value. But thereafter, my lords, the next column, serial number 138, my lords, the third. Thereafter, my lords, the total taxable value, my lords, may kindly see it. It is 25 crores 34 lakhs 83,056. Just, my lords, because of the fact that the decimal places 056 has been added additionally, my lords. My lords, may kindly once again see page 37.
Yes.
253,463.56. Taxable value, my lords. One. Fifth column, my lords.
Got it. Got it.
And here what had happened is by mistake, I had disclosed it 25 crores as opposed to 2,53,000, my lords. So therefore, I was called for summons. And my lords, on being satisfied with my response, my lords, page 70 kindly takes
70.
page 70, my lords. So, my lords, I would also like to, being an officer of the court, I like to indicate that this order was not served to me in my order in the ordinary course because this is an order passed in the summons proceeding. Because all this was served upon me subsequent to this passing of this impugned order, I had written to the concerned authority to pass me to supply me with a certified copy, and basis thereof, I have been able to obtain this order. May I kindly read it for my lords? Mr. Abhay Malik, the AR appears in connection with the mismatch with GSTR 1 and GSTR 3B of value of rupees 1,26,61,573. Mr. Malik states that Ghosh brother has not made such a huge supply to Swapan Kumar Sarkar and the difference that is apparent is crept into due to clerical mismatch. When asked to corroborate his claim with documentary evidences, Sri Malik produced party ledger of Swapan Kumar Sarkar and bank statement of Ghosh Bharat. The statements have been gone through. In the BO portal, it is seen that the mismatch is mainly pertaining to December 2017 when GSTR 1 services made to party.
Yes, I have read it. There is no mismatch.
There is no mismatch.
And
Now, my
tax
lords,
is payable.
yes, my lords. So this had concluded, my lords. Thereafter, my lords, a show cause notice was issued, my lords, a pre-intimation. But my lords may kindly first of all take the screenshot, my lords, to indicate that everything was under additional notices and orders, my lords. Additional tab, page 56.
56.
My lords, as is page 56. It is additional notices and orders tab. So
And the earlier proceeding,
yes.
how was this served?
So earlier proceedings was all physical, my lords. This was all portal, no other mode of communication. And my lords, I just like to also draw my lords' attention to the fact that it is arising out of the same proceedings, my lords. May kindly see.
The earlier proceeding was under which section?
It was under section 70, my lord. So I was summoned.
Where is the notice?
My lords, I had shown, my lords, kindly take page number 39.
Is 39.
My lords, subject notice under section 70 of the WBGST Act. So, my lords, had they found it not to be in order, they would have thereafter proceeded to issue a show cause notice under 73 or 74, as the case may be.
It's only power to issue summons.
Yes. So in summons, they have asked me to tender this clarification. I responded. They agreed. They pass an order, which was in the form of an order sheet. That order is not served, my lords, in ordinary course because it is not an order under 73 or 74. Subsequently, my lords, on the self-same issue, notice is issued under the additional tab. Order is passed under the additional tab, my lords. Now I'll just take my lords to the fact that it is arising out of the same proceeding, my lords. We'll clearly get it from Annexure P10, my lords, which is at page 62.
Page 62.
Page 62, my lords, which is the show cause notice issued under section 73, my lords.
Yes.
My lords, may kindly see the table. So the tax exact amount is, my lords, exactly matching with that 1 crore 26, my lords, which I had initially showed to you. And this is again entirely based on comparison between GSTR 1 and GSTR 3B. Lords, I'll just like to hand over also a screenshot from the portal to clearly bring on record that no personal hearing was also granted. Just need to include this.
Well, can you bring on the matter back because the authority did not have the opportunity to see the report or the order of the
Well,
central GS.
This is the same authority, same charge, same authority. It is
Mr.
state.
Mr.
State.
Chakraborty,
This is
why don't you come up with a report as to in the if in the light of this
observation.
revelation,
I'll come back.
whether the order can remain because if
No,
the
it cannot,
authorities-
man. It cannot.
then in
But
that
prima
case,
facie,
from
but,
on the basis of your report it can go
yes, ma'am.
because unnecessarily I'll be sending him back. You will decide. You file a report indicating as to whether the order can still be sustained
In
on the
view of
basis
that.
of that. Then I'll ask him to go before you for a hearing.
My lords.
My lord.
এ থাক, চেঞ্জ কিছু হবে না। এই বললাম।
Much obliged.
For the assessment year 18-19, on 31st April 2000,
এইটা
21st
দেখুন,
of
রয়ে
April,
গেছে ওই আগের ফাইলে ঢুকলো। Yes,
on 21st of April 2021, the assessment order passed for the assessment year 18-19. Subsequently, we preferred an appeal against the assessment order. Then we made an application for order under section 220, subsection 6. The order has been passed in favor of the assessee, my lord. Kindly see the order first, my lord, then my lord, I'll coming to the 6th of October 2025. The order has been passed. Kindly come to page 58 of the writ petition.
58.
50.
Yes,
The instant case, the assessee was completed on 21st of April 2021, raising a demand of rupees 25 crore 94 lakhs for the AY 18-19. The assessee being aggrieved against the order filed appeal before the CIT appeal NFAC, and the same is still pending. Now the assessee filed a petition dated 17 September 2025 with a request to stay the demand till the disposal of the appeal before the CIT
so
appeal.
it was granted.
It was granted, madam, as per the CBDT instruction 191. Then, my lord, they have issued the 1245 notice under section 245 for adjustment. We made an application for, we raised the objection, two objection we have raised. Although they are not disposed of my objection, they have recovered almost 8 crore 13 lakhs 51,240 rupees for the period, for the assessment year 2021, for the assessment year 2021, madam.
The stay was for 18-19.
18-19. Well, it is apparent from the status and the challan also, my lord.
So
Well,
for
kindly come to page
2021
175. My lord, the two challan they have recovered. My lord, page 175 is the challan, first challan. 7 crore 28 lakh 86 67,780.
Page 175.
175 annexure P16.
Yes,
Then, my lord, kindly come to page 176. 84 lakh 83,460. The amount in rupees, my lord. For the period assessment is 18-19.
this stay was also for 18-19.
18-19.
Yes, Mr. Dutt, how could this be done? If they have stayed the demand, how can they proceed and recover?
Yes, Millard, the assessing officer informed me, Millard, that he had uploaded the no recovery certificate in the portal, and also say that the assessee has paid 20%, therefore there is automatic stay. But Millard, still the CPC has deducted.
They have to refund it.
Yes.
Because if you have passed an order of stay,
Yes, absolutely.
then in any case,
Millard,
you should
I
not
have nothing to say.
Great.
leak it. comma, no accommodation is paid for,